has been widely reported now. There's a very serious tug of war on the ban of tobacco sales. Government says one of the reasons for the ban is fear that the product would lead to higher transmissions of COVID-19 in poorer communities. About 4,000 pages have been submitted by the National Coronavirus Command Council on why smoking during the pandemic is risky. The submission follows a court application by the Fair Trade Independent Tobacco Association to challenge the ban on cigarettes. Let's get a legal expert and legal opinion. I'm joined now via Skype to unpack this by legal expert Nthabiseng Dubazana. Nthabiseng, good morning to you. Thank you for your time. The health risks associated with smoking are well known. I think very few people will argue that. Let's talk legally. The way government has done this, what is the legal standing on this and how can it be challenged?
Well, I think the tobacco industry has tried the constitutional route, which is the correct way because the right to free trade and everything is guaranteed in the Constitution. But also we must remember that every right in the Constitution can be limited in terms of Section 36 of the Constitution. So if your right entrenches so much on another person's right, therefore minimizing a major group of the society's rights to health, for example, in this specific case, then the Constitutional Court or even the High Court, where the matter is currently being heard, can therefore say that constitutionally the government could have acted in the best interest of the society, and therefore the ban could be considered to be legal. It's actually a 50-50 kind of situation, depending on how the arguments on both sides for the constitutionality of the banning on the side of the state and the constitutionality of, lifting the ban from the side of the tobacco industry could work out.
Some people in Nthabiseng are calling this an overreach of government's intervention. Is that a fair analysis?
Well, considering where the government is coming from, in less fortunate societies, cigarettes is not whereby one person can buy a packet and then they smoke it themselves. It's usually passed around. And as that is also the case with regard to secondhand smoking, that's why, there's also a separation of smokers and non-smokers in public areas. People who have underlying health issues such as asthma and sinusitis, I guess, can also be affected by if they contract the COVID-19 virus. So I don't think it's overreaching per se, but I would say that perhaps maybe further consultation or assistance for the public in order to handle the situation better would have worked better. But if in the consultation, the scientific evidence that has been given to the command center, and it says that it does not make any sense for the ban on cigarettes to be lifted, then that's what they should stick to.
From a legal perspective, how compelled is the National Coronavirus Command Council obligated in law to provide those documents? We know they've given 4,000 documents over. Is there anything within the NCCC that can be protected under state security? Is that a thing?
Yes, there is a thing whereby certain information cannot be revealed to the public. That is a legally, confirmed thing. However, if it is necessary and it does not affect the public in any manner or form, then they are obliged to give to the opposing party, which is the tobacco industry, and also the public as a result, the research and all 4,000 papers regarding why they are saying that it should not be lifted, the ban on tobacco substances. Legally, they have to. Because, as if I'm going against you in court, we have what we call discovery. I have to give you what I have in my case, and you have to give me what you have in my case, so that I can prepare thoroughly in order for me to counter what you have, in order for you to counter what I have. So they have to give out what they have researched and found to the opposing party and vice versa. However, if in part of those 4,000 papers, there's certain information that cannot be allowed to be public knowledge, they can make an application to the court and say, as a result of this information in this document, can we request that this not be made public knowledge? 1, 2, can this not be made part of the discovery to the opposing counsel? So that is the way that they would go in this situation.
Beyond the Constitutional Court, which is the highest court in the country, in Nthabiseng, what are the options for those who are opposing this? Once they've exhausted all their legal options, what else is there for them to do?
Well, right now it's in the High Court, Should the state win in this situation, then they can appeal to the SCA and then finally to the Constitutional Court. Beyond that, there is absolutely nothing. The Constitutional Court is the final word on everything. So if the Constitutional Court goes with the state in this regard, the ban remains. If the Constitutional Court goes with the tobacco industry, then the ban will be lifted.
I did see a question regarding the Constitutional Court in Thabiseng. I hope you don't mind me asking you this. When a regulation has been put in that affects the freedom and the constitutionality of South African citizens, why has this not gone straight to the ConCourt? Why is it going through the lower courts first?
Because sometimes we can make an application directly to the Constitutional Court, but if on review of the papers they feel like it could have been dealt in the lower courts, then they will refer you right back to the lower courts. So in order to cover yourself and not bar yourself from being prevented to go into the Constitutional Court, rather start in the lower courts and deal with the constitutionality of the matter there. So that when it is dealt with in the Constitutional Court, it was already regarded in the lower courts as well.
One of the other questions that has been asked on a number of public platforms, I'm not suggesting social media speaks for all of South Africa, but if you do look at social media, people are asking, what is the legal framework in place that at some point, whether it's level 2 or level 1, that will compel government to lift the ban if the argument is that it is bad for people's health? What legal framework is in place to compel them to lift the ban eventually, whether that's level 2 or level 1? Essentially, what's going to stop them from keeping this in place going forward?
Honestly, I don't think there is any legal thing that we can look at. This is a unique situation. The Disaster Management Act is being used because this situation has not been dealt with before. So at this stage, the regulations and the laws are being developed as we go on. So we cannot generally say that in level 2, the ban will still be there because 1, 2, 3, 4, or the ban will be lifted as a result of maybe the outcome of the case. We actually don't know what will be the legal recourse should we get to level 2, what would be the situation there. Because the situation, as we all know, is very new and unique, and we're trying to deal with it in both legal terms and other ways as we go along. But what I can possibly say is that should the outcome of the case be in favor of the people, which means the tobacco industry, and then the ban is lifted, then probably the regulation that will come and follow will be on regulating how tobacco substances will be sold and consumed, just like they're doing on alcohol as well.
A wonderful legal opinion. I appreciate it this morning. Expert in Thabiseng, Dubazana, thank you very much.